This was, at its heart, an elder abuse case involving falls, neglect, just lots of different care issues that painted a picture of a facility-wide pattern of neglect and just failure to take needed steps to keep Theresa Donahue safe.
Howdy, and welcome to the show. I'm very excited to have another one of our after action reviews where we're going to do a deep dive into a recent case and an outstanding result. Today, we get to sit down with Karman Guadagni and Kelsey Craven, both from Stebner, Gertler, and Guadagni. They're going to talk about their successful trial, in the Donahue versus MBK Senior Living case. And it's not just one trial, it's two trials, because there was a hung jury along the way. And without further ado, I'm going to ask to just turn this over to one of the two of you to tell us a little bit about what happened, the underlying incident that gave rise to this.
So the essence of the case surrounds decedent Theresa Donahue, who was in her 80s when she was admitted to Muirwood's Memory Care, which is a memory care facility in Petaluma, California. And she was basically admitted because she had dementia, and her daughter thought that this facility would be a place where her mom could stay safe and where she could remain active and have activities and such. And so she was admitted a few months after the pandemic, the COVID pandemic started. And throughout her admission, she suffered at least 4 falls. And on the 4th fall, on March 20th of 2021, she fell and suffered a hip fracture, which ultimately led to a severe decline and her passing about a year later. I actually did the intake for this case with the daughter, Kelly Tenier, about a few weeks after that final fall, when her mother was still alive. And we filed the complaint soon after. And so we had the opportunity to get to know Theresa and her family before she passed, which I think made a big difference in terms of knowing who she was as a person. You know, eventually she did unfortunately pass in April of 2022. And at that point, we had to file an amended complaint, adding a cause of action for wrongful death, and then had her 2 children as the plaintiffs, Kelly Tenier and Raymond Donahue. And so this was, at its heart, an elder abuse case involving falls, neglect. It also, included Miss Donahue getting scabies for an extended period of time. Just lots of different care issues that painted a picture of a facility-wide pattern of neglect and just failure to take needed steps to keep Theresa Donahue safe.
While we're here to talk about the workup of that case and the ultimately successful outcome of that case, can you help us understand a little bit about how elder abuse cases are different than your everyday personal injury case? Are there additional hurdles, additional challenges that you need to be aware of to do these successfully?
Elder abuse cases are different than a standard PI case because you're not just proving negligence. We like to say it's kind of like if you're proving an injury case plus you're proving like a product defect case. In order to get elder abuse in California, you have to show not only that the incident happened and it caused the injury or caused the death, but also you have to show that the managing agents, the people who are really in control and in charge of the facility, made decisions that were reckless or malicious or oppressive, but usually reckless, in terms of the way they operated, that they knew of risks that could come from not doing certain things, but they disregarded those risks, often for a profit motive. So the most common ways that we prove that, and what we did in this case, is showing that there wasn't enough staff, that they knew they needed more staff, but they chose not to take steps to get more staff and continue to admit new residents, that the staff wasn't trained, and that the management is not supported and not adequate to oversee the provision of care.
And to give that back to you to see if I understand it correctly, it sounds like the standard is a higher standard, higher burden.
It is. So in order to get elder abuse, you have to get clear and convincing evidence. So, it's the next thing to beyond a reasonable doubt, really.
I know this is a little tangential, but relevant to the practice area. Am I correct that there have been some efforts at the legislative level to correct that standard, given our aging population and given the unfortunate commonality of these kinds of events?
In order to prove financial elder abuse, the burden is actually lower than it is for proving physical abuse. And so our firm, our principal, Catherine Stebner, recently was the CAOC president. She and us collectively have made a big push and a big effort, along with our co-counsel, Kirsten Fish, to try to change the standard of proof to lower it to a simple preponderance. We, last year during the legislative session, were able to get it through the ledge, but the governor vetoed the change. We then have worked with some people in Sacramento to have a new modified bill on the table, which would say that if you could show basically falsification or destruction of evidence in an elder abuse case, then at least the judge has the discretion to lower the standard of proof. And that's in the works right now. We'll see, but we're really hoping we get it through.
With that standard as a backdrop, can you help us understand how you approached the discovery in this case, discovery depositions workup, to get it ready for meeting that higher burden?
So I think it's interesting and important to remember that we filed the case less than a month after that fourth fall happened, so in April of 21. And at that time, Theresa Donahue was still alive. We filed a motion for preference. We do that in a lot of our cases, but once the motion for preference was granted in June of 21, the case was set for trial in the fall. And so we were all just kind of rushing to do everything we could to get it prepped. 4 months is not a long time to get a case ready for trial, regardless of the standard of proof. But the bulk of the depositions and the bulk of the discovery was done during that window. And that was also while we were all in the middle of our pandemic kind of lockdown. So everybody was doing everything from their home offices or bedrooms. But what was interesting is sort of in that hasty process, we got the basic information where we felt like we were ready to try it. But a lot of information came out during the trial, which hadn't been uncovered in discovery. And so it's kind of counter to the argument, like you never ask a question you don't know the answer to. There were a lot of new pieces of information that we learned about after. And so we ended up having to, in the course of the trial, take probably more risks than we otherwise would have to deal with it.
I want to unpack that a little bit. One question I didn't ask: venue. Where was this located?
This case was in Sonoma County.
If my memory serves correctly, your firm has had a number of significant outcomes in Sonoma. Are there more homes up in that area? Is that why there are more cases up in that area?
There are quite a few long-term care facilities in that area. I mean, generally, the number of long-term care facilities in an area in California directly correlates to how cheap the real estate is and how much of the population is elderly. So there's a lot of elderly people in sort of the North Bay, and the real estate is cheaper. It's less concentrated, for example, in San Francisco, where real estate is more expensive.
With the number of cases that you have, is MBK Senior Living a repeat offender, someone where you would have had some background information to help you as you're going through this process?
So we have had in the past other cases against MBK Senior Living. MBK isn't our most common defendant, but we had experience with them in the past. But we never got to the level, of course, that we did in this case.
Understood. Going back into the pandemic phase and learning more things during trial than one normally does, how did that come about?
There's so many examples. I'm having a hard time coming up with the first one. But, I think a big one that we learned during the first trial was that the administrator, the synonymous term is executive director of the facility, her name was Jamie. We did not know this before, but we learned that during this time where Theresa was falling a lot, when she suffered the hip fracture, all of that, the administrator was actually sick herself with COVID and was not physically present at the facility. It was for quite a long time. It was for a period of months, and she was really sick, actually. But the corporation, instead of sending in her supervisor or someone to fill in for her, they just had her working remotely, basically. And so, the captain of the ship was not there during this vital period of time when Theresa was having all of these falls and nothing was being done.
That sounds to me like it would be a helpful fact. I'm going to ruin the chronology of the plot a little bit, but what happened with the first trial?
With the first trial, we were in trial for 5 weeks. We had the jury deliberate, I want to say, for 2.5 days. Right after the case went to the jury, our judge for the trial went to take his kid to college. So we got a substitute judge. And then the jury started sending in notes. And the notes painted an increasingly bleak picture over that time. And then we learned that the jury was hung, that they couldn't get to 9 on the first question on the verdict form, which is the negligence question. And so the judge dismissed the jurors and we walked out.
And I was making presumptions. I'll ask a question. Was this tried remotely or were you in person?
We were in person for both of the trials. And actually, during the first one, one of the jurors contracted COVID. And so that was also another hurdle of, I believe you were on a recess for a couple days trying to figure out how to logistically go about this with someone testing positive. I also got COVID during that time. So that was a big hurdle there, and just in terms of logistics. But yeah, it was, there was a lot that we learned from the first trial, I would say.
The reason I asked about whether you were in person was once the jury came back and was hung, were you able to, in essence, do a 5-week focus group to figure out how to retry the case in terms of what some of the jurors had to say about things?
Yes. After the 5 weeks, the jurors really shot out of the parking lot. They were not hanging around. There was one that I was able to talk to that day, but everybody else was gone by the time we were dismissed. But then we were able to track down almost everybody. I'd say probably 8 out of the 12. Or there were 2 alternates. So I think I talked to 8 or 9 people. But we did get a lot of information. We also found some really interesting things about our jurors. One of the surprising things we found out was that the foreperson was a gentleman who had some prior criminal history and probably wouldn't have been allowed to serve on the jury. But we also found he was somebody who had gone through litigation, in his own personal life or whatever. And he was very against us and very against our case. One of the, so we use negligence per se because a lot of what we're talking about in elder abuse cases has to do with the regulations and specific regulations that apply to long-term care. So the defendants in both trials were able to get the judge to give an instruction that the negligence was excused because of an emergency, the COVID pandemic. So, we were a little hesitant initially to go into the trial talking so much about COVID, and then our hand was really forced. And it became clear during the trial that, there was this big, huge COVID outbreak at our facility while Theresa Donahue was having all these problems. And so we ended up talking about COVID a lot. But to go back to your first question, what we learned after the first trial, in part by talking to the jurors, was the defense did a good job in the first trial of painting the picture that the facilities and the management's hands were tied, that this was an emergency. And so when we got ready for the second trial, we really addressed that head on and really focused on the options and the choices that they had at every turn, and the fact that they chose not to do the right thing over and over. And I think that was ultimately effective.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. Going to the process after a hung jury, were you allowed to reopen discovery? Were there more depositions, or did you have to try it with the same hand that you held before?
We took a deposition on the defendant's financial condition. Sort of in the event we were to get a punitive damages finding, we would have a baseline set of information, which really did prove crucial when we did get that punitive damages finding, to have that testimony later on. But I think beyond that, actually, there was one other deposition. I think someone from the state of California licensing.
Roughly how long after the first trial was the second trial set?
We were set to start on March 1st of 24, and we got the hung jury, is it September?
September of the previous year. So about 6 months.
Okay. And one question I didn't ask earlier, much like medical malpractice, there seems to be a very narrow band of people who specialize in this area on the prosecution side, firms like yours who do it really well. Is that also true in terms of the defense firms? Do you see the same people over and over again?
I would say for the most part, yes. And, that's a good and a bad thing. It's good because, the other side knows what they're doing. And when you see someone inexperienced show up, it's not necessarily a good thing, because it often means you just have to have a lot more unnecessary fights. But the defense in this case was someone that we're really familiar with. I mean, it's one of the preeminent defense firms in California.
At that level, is it a collegial bar, or is it still pretty bare-knuckled?
I'd say largely collegial, but it's very adversarial. We could talk big picture on a good level. And there were lots of things we were able to stipulate too at trial, things like that, but certainly not that comfortable of a relationship.
Understood. I recognize that you had between the preference and COVID, you had very challenging circumstances in terms of pulling together the information before the first trial. Are there things that you wish you had had the opportunity to do or to do differently in order for that initial workup?
A lot of the things that I wish could have been done differently were out of our control.
The only thing is there were so in our case, one of the issues is our focus is trying to prove there wasn't enough staff at this facility. And we jumped on filing our complaint, and we jumped on serving our written discovery and document requests. But by the time that we got responses, the staffing documents had been destroyed. They said it was in the regular course of business. I'd say, looking backwards, had we known where we were going to end up, we would have filed motions to compel, and we just didn't have time in that preference window to have our motions even heard. But, I think the destruction of documents would have given the judge more power to do more with that if we'd been able to file motions and kind of go all the way through. We didn't have that chance. But ultimately, we did get the jury instructions on destruction of documents. And, I think that they really helped us in our case.
Also, in terms of what I would describe as the setup for a very successful financial outcome for your clients, did you serve any sort of a formal offer of compromise, a 998?
We did. So we served a 998 for $990 about a year and a half before the first trial. and the defendants had served a 998 for $85,000, which would have been about a month before we were originally scheduled to go to trial. So in September of 21, and we beat that.
Yeah. Did you win the second trial?
I'm very pleased to report we did not get a second hung jury. Yes, it was a moment I'll never forget. I don't have the verdict form in front of me right now, but I just off the top of my head, we did win on elder abuse, and the pain and suffering award was $3.5 million, as well as a few $100,000 in wrongful death damages. Then for the punitive damages phase, that was a really, really quick turnaround. I think Karman was able to question the CEO of the company for less than 2 hours. And then the jury deliberated for about 2 hours and came back with a $17 million total punitive damages award.
Wow.
Yeah, almost. I remember our client was standing in between us, and I almost had to hold her up because her knees were buckling. She just couldn't believe what had happened.
When you get into the overlap of insurance and the corporate assets on a punitive damage case, with the 998 having been served, I'm making some presumptions. Was there insurance in play in this case?
There was $1 million policy.
So with the $1 million policy and a 998 for less than the policy, I think you said 990 if I recall correctly.
Correct.
How did that impact the ultimate collectability in the case?
Zooming way back in time to before we knew this case was going to try, this was a hard case. This was a fall case with a lot of time between the fall and the ultimate death. So in the elder abuse world, fall cases are probably the hardest cases. We were open to discussing settlement up until a certain point, but, within the policy. Our client was very interested in getting justice for her mom. So, what number that would have been, I'm not exactly sure. But in terms of ultimately now collectability, the company, the parent company of MBK Senior Living, has tremendous amount of assets. So I don't think they're going to go bankrupt. The case is still on appeal, so the money's in an account collecting interest right now.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.